Welcome everyone. We are today discussing non-compete clauses, specifically in M&A situations, and the enforcement aspect. If you have any questions, please write in the chat box. Make sure that as soon as you have a question, you write it down, because if we have time, we will take them up. If some questions comes at later part of or at the end of the session, we may not be in a position to take it up. All the questions we'll try to answer during our discussion, if it is possible, time permitting. If we can't answer those questions, we will actually take them offline and do one-on-one answers. With this, let me tell you what we plan to cover today. What we plan to cover today is on non-compete clauses. We will actually look at how the non-compete clauses are drafted. We'll look at the relevance and the importance of this, and we'll also look at the enforcement aspect. The reason we thought to take this non-compete is, in my 27 years of experience, this is one question which have been constantly coming. Whenever there is a M&A or even otherwise, there's always a situation of, I was working in this particular company, I'm now going and joining some other company. Am I violating non-compete clauses, right? That's if it's a founder or a senior employee who is actually asking this question. There have been situations where companies have asked, hey, this guy is planning to leave and go somewhere else. He's joining competition. How can I protect myself, right? So we get this kind of questions very often. Also, in some situations, these are not relating to employee; they are relating to commercial parties, right? There has been a contract, and a contract has been signed, and then there's a business party relationship, a joint venture, and then there's a joint venture break, and then joint venture terminates, and now you end up going and doing a business which is going to compete. This kind of questions keep on coming, whether it with respect to private equity investments, which have investment in more than one entities, and then, whether those are competing entities or not, or, can they invest in competing entity? So non-compete aspect has become very, very critical, especially when you look at transactions. It has even become more complex and important. So that is the aspect which we're going to touch today. We will not take some of the traditional stuff. We'll try to focus more on transactions like M&A, and we will see how the non-compete clauses play a role there. With this, let me go to Saumya. Saumya, can you first address, why are non-compete? I already gave kind of a little bit of a flavor, but can you go in detail to say why non-compete, restrictions are important or relevant in M&A?
Sure, Vaibhav. Thank you. So taking off from the tone set by Weber for this, let me just lay out two scenarios in front of the audience, which will help us understand why really non-compete is critical both for the seller and buyer, and why negotiating them is a challenge. So let's talk about a scenario where, let's say, there's a company A. Company A is, let's say, involved in the business of running coaching classes for preparing students for IIT. Company A is sold off. So the promoter, it's a 100% acquisition. The entire shareholding of company A is sold to, let's say, company B. And as part of the entire acquisition, the promoters of company A, by now, who have their names associated with the brand in the business of running coaching classes, etc., they are not part of the management anymore after the acquisition. Imagine a scenario from the buyer's perspective where the promoters of company A, let's say 3 months after the acquisition, again set up another company doing exactly the same thing, and pretty much the entire goodwill, the entire business, or a majority of it goes to the new entity set up by the promoters of company A. This is one scenario to consider. The second scenario is, let's say, in the same example, the promoters have, in this case, let's say, signed up to a non-compete clause. In that case, what really happens is The promoters of company A are primarily into academics, and being restricted by this non-compete clause leaves them with very little option to earn livelihood or carry on a trade or profession after the acquisition has taken place in case they've signed a non-compete clause. And there is a scenario here, the business of the buyer is protected because there is a non-compete clause in favor, restricting the promoters. But the promoter is really in a dilemma because there is not much that, in terms of skill set, that the promoters have. So these are the two scenarios which I think sort of draw out like what a dilemma generally comes into play when you're negotiating these sort of non-compete clauses. So let's look at it from both the perspective of the buyer and seller. So usually it's the buyer who insists on what we call a huge bracket of restrictive covenants. The most important one being the non-compete. There are also other restrictive covenants like non-solicitation, confidentiality, protection of trade secrets, etc. But here we are focusing on non-compete. So usually what happens is in a dynamic age like this, when a buyer acquires a business, it's not only the factory, it's not just the equipment, it's not just the employees that the buyer is investing in or purchasing. It's the entire IP, it's the goodwill, it's the reputation and the value attached to the brand that the buyer is investing in and putting money into. And from a private M&A perspective, this usually comes at a premium. So so usually when a private company is being acquired, the way the valuation is determined sort of has a multiple effect, and usually factors like these are considered. So from a buyer's perspective, if the promoters of that company were to be able to set up exactly the same business without really any gap, it's almost as if the buyer is not able to realize the value of the investment made by the buyer. So hence, from a buyer's perspective, it's very, very important because it in effect dilutes the value of the acquisition made by the buyer. Now, coming to the seller's perspective, of course, it's not the most beneficial aspect for the seller per se, but considering in commercial transactions like, and as Weber pointed out, especially in acquisition deals where there's a complete transfer of ownership, it is something which is very common and standard in deals in India. And from a seller's perspective, there is very little argument or chance for the seller to not be bound by this restriction. But it is very important then from a seller's perspective to clearly define what these restrictions are going to be, which we will also discuss in detail when we talk about how these clauses are usually negotiated and what are the points to be kept in mind. Weber?
Thank you. While you are it, why don't you also tell about consideration? Because there is no clause,
Sure.
right? I mean, there is no covenant which you put in without making sure there is a proper consideration. So, how is consideration for non-compete structured?
Sure, sure. To answer that, let me just take a step back and also look at who really are bound by these kind of restrictions typically in an acquisition deal. So, like I pointed out, first and foremost, it's the promoters because they are the people who are running the business. Their names are associated with the brand and the business. The second category of people are basically the selling shareholders. This is basically where the dilemma comes in because now some of the shareholders may just be passive investors who are financial investors and have not really been involved in the day-to-day operations of the company. And they can always claim that, look, I have no or goodwill as per se from the business, and my investment was purely financial in nature, and hence they may argue that we should not be bound by non-compete. However, if it's a strategic investor whose role was a little more deeper into the operations of the company, usually they are also bound by non-compete. And the third category of people are the key employees of the company. So basically, this category of people are the ones who are not necessarily the shareholders of the company, but in some cases, the buyer may want them to be bound by non-compete, especially if they are not transitioning over to the buyer's entity, because they think the value that they bring to the table, if they go and take it somewhere else, again, the value of the acquisition may get diluted. So now looking at these three categories of people and from a consideration perspective, what we see overall is that when, like I said, in a private company acquisition, usually there is a premium attached to the valuation. That is how the consideration is determined. And the way your non-compete clauses are worded is that the consideration which is calculated for the business in its entirety is inclusive of not just the value of the shares or the value of the company per se, but it also includes sufficient consideration that is being paid to, let's say, the promoters or the selling shareholders for them to be bound by these non-compete restrictions. Here, I would like to point out the issue with respect to key employees. Now, what really happens in case of key employees when they are not signing up new employment agreements with the purchasing entity? So, and they are also not shareholders of the entity that was sold. So, pretty much you're talking about a scenario where they've not really received any consideration as such of the entire acquisition. It becomes very difficult for such people to be bound by non-compete, like Weber said, because of the absence of consideration. However, like I said, for promoters and for the selling shareholders, usually the way it's structured is that the consideration that is being paid to them towards the purchase of shares at a premium is sufficient consideration for restricting them. Weber?
Thank you, Saumya. Before we go more on drafting and other things, I would want to turn to Alipak and ask him, but what does Indian laws talk about, non-compete? Can you just say what is the position of law here?
Thank you, Vaibhav, and hello, everyone. I think the starting point of this analysis would be Section 27 of the Indian Contract Act, which basically restrains any agreement which is of trade. And the clause, Section 27 states that every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. Now, there's an exception carved in this section, and that is the basis of the kind of clauses that we see in investment agreements. And the exception says that one who sells the goodwill of a business may agree with the buyer to refrain from carrying on a similar business within specified local limits, so long as the buyer or any person deriving the title to the goodwill from him carries on a like business therein, provided that such limits appear to the court as reasonable regarding to the nature of business. So the courts look at reasonability and the nature of business, and if the transaction involves the sale of goodwill, agreements in restraint of trade, which would be a non-compete obligation, to that extent can be upheld. Now let's look at, before I jump into a few cases, let's look at the jurisprudence which has evolved over the last 40 or 50 years. So first, let's look at the rationale behind this. So the general principle behind this provision is that an individual who is entitled to exercise his or her lawful trade, and that is granted to us by the Constitution as well, that law guards against interference with the trade, even if that means interfering with the freedom of contract. And the Supreme Court and the various high courts have consistently taken the view that negative covenants can only be enforced to the extent they are reasonable. And the purpose of the covenant is to protect the legitimate business interest of the buyer. Even in that instance, even in such circumstances, the restraints cannot be greater than the necessity to protect the interest concerned. The approach adopted by Indian courts with respect to employees is that such restrictions during the period of employment are valid and considered legitimate for the protection of the business interest of the company, and hence they do not violate Section 27. It is sort of towards fulfillment of the employment contract and not in restraint, because the concerned person is still with the employment of that organization. However, the survival of such restriction beyond the terms of employment or beyond the period of employment has been a matter of debate in several cases, and which I'll discuss in a minute. Now, the courts have generally held that the right to livelihood of the employees must prevail over the interest of the employer, and that's how they have sort of balanced the interplay of the restrictive covenants. Now, I'll just cite one case law over here, and then maybe I'll deal with the other landmark decisions subsequently in the presentation. The Delhi High Court in FA Holding Pte Limited versus Saurabh Singh. This is a case which was reported at length. It held that a negative covenant in the employment contract which prohibits carrying on competing business beyond the tenure of contract is void and not enforceable. So with that, I would stop here, and then maybe later on I'll come back and explain what has been the journey since 1960s to the present time, and what is the approach the Supreme Court has consistently taken in various facts and circumstances.
Thank you, Alipak. I think as we all appreciate, the Section 27 of Contract Act, right, has come over 100 years ago. The business at that point of time, the way the business was done was very different. The concept was very clear that you want to have as minimum restriction as possible when somebody is wanting to do trade. So any restraint on trade would be a little bit difficult to enforce, unless the exception was there, a sale of business with goodwill. But a lot of things have changed in the way business has been done, right? And I will take it up, during our discussion a little bit on some of the questions which have been coming to us, right? And the position which is possible. These questions can relate to, what is sale of business, right? It can also be related to, they say that, you need to have a limited time frame and limited geography, right? So reasonable time and reasonable geography, right? So question also comes on geography. What is a reasonable geography? What is a reasonable time? Even when it comes to geography, is it a physical geography? We are now currently doing a lot of business online. And when you do an online business, right, the relevance of geography is immaterial. So how do you create, how do you really put those restrictions, right? And, we'll talk a little bit more on that, but there's a lot of questions which comes in line with the modern methods of doing business, right, on developments which have happened. But the law which was set up was actually set a long back. And that's why the jurisprudence and the case laws are important to understand, what is the direction which courts are going and what likely situation will happen if all these questions come to the court. We'll take that up later. Let me go back to Saumya. Saumya, drafting of a non-compete clause is very important, right? Because ultimately, if there is a litigation or enforcement, and in a situation where it is difficult to enforce, right, based on what Alipak mentioned, this is what goes into court when judge has to see, right, what exactly is the clause. So how do you draft it, right? What are the key considerations which you should keep in mind while drafting this clause?
Sure. So let me again break this down into a few questions to explain this better. So first, let's try and understand what really does a non-compete clause restrict. When you carry on a competing business, what does it exactly mean? And this is where the drafting comes into the picture. So one of the most sort of, if I have to start with a one-sided non-compete clause, so when I say a one-sided non-compete clause, it's mostly in favor of the buyer. Usually, in that case, what it says is that the promoter or whoever is bound by the non-compete is usually restricted from carry on a competing business. And in a minute, we'll come to what competing business is, either as an individual employee, consultant, as a shareholder, as a contractor, through relatives, or through multiple forms, directly or indirectly. So it's sort of, and also whether for profit or non-profit. So it also prohibits the person from carrying on that business without any consideration involved. So these sort of restrictions are standard and also common. The idea is that the promoter should not be able to circumvent the restriction by starting the business in the name of a relative or through a corporate entity or through some form of structuring. So any form of direct or indirect engagement, either as a shareholder or a consultant, contractor, employee, is usually what is prohibited. The second key concept is what is business. So what is it that you're prohibited from doing? So here is where the most amount of negotiation really happens, because you're looking at what is really business for the purpose of this restriction. So obviously, from a buyer's perspective, you would want to keep it a little broad to maybe sort of cover the ideas which probably the promoter came up with during his time but were not really implemented prior to the transaction closing. However, the promoter may want to only limit it to the business that he was actively involved in. So here, negotiating and sort of specifically identifying what business is the person prohibited from doing becomes very, very important. Also, please keep in mind that this also has an effect on enforcement, because like Alipak pointed out, this whole test of reasonability becomes very important. So, and we'll also look at how all other jurisdictions see these kind of clauses. Sometimes we've seen an approach whereby, parties just want to keep it as broad as possible, and then, with the hope that one day if it does get litigated, then the scope of the restriction may be narrowed, etc. However, from the perspective of really the commercial intent of the parties being clear, it's just best to identify what it is that the promoter is restricted from doing. And I would also just like to add on to the 2 points that Vaibhav covered. One is on the geography and the other is on the time period. These are again two very, very important concepts. So geography, of course, the most common limitation that we've seen is worldwide, but usually that really doesn't work. And I'm sure Alipa can throw some more light on it from a case law perspective, because it that is something that is actually in restraint of trade. So usually the idea is that wherever really the business which has been sold was active, maybe identify the city or state, and limit the restriction to that geography. Similarly, on time period, there are three categories which become very important, that trigger the time restriction on non-compete. One is shareholding, one is employment or consultancy, and the third is directorship. So again, all of this really depends on whether there is a management change after acquisition or whether the same team is continuing. So usually, like Alipak pointed out, during the term of your employment with the company, there is no issue with enforcing these. So that is something that is definitely granted. Sometimes what we see is we see promoters asking for, the minute their shareholding, let's say, gets diluted to about 10% or 5%, their argument becomes that, we are after reaching that lower threshold, we are more or less passive shareholders in the company. Hence, we should not be bound by such stringent restrictions. So these are some of the key things that we should keep in mind when we look at the time period. Also, one last point from a drafting perspective is, largely with the diverse interest that we see in young promoters these days, we also see a lot of negotiation around exceptions. For example, we've seen promoters asking for an exception whereby they should be permitted to make purely passive financial investment in even competing businesses, so long as they are not involved in the day-to-day operations or they are not getting any special rights as part of these investments. So some of these exceptions are also heavily negotiated these days. So these are some of the broad categories that one should keep in mind. Weber?
Thank you. Let's take the geography aspects, right? So very interestingly, a question always comes to me, and it's been coming lately. Is that when we say a particular city or a particular country or worldwide, right? And again, we all know that when you put worldwide, the probability of enforcement reduces, right? So the more broader geography you cover, lesser are the chance of enforcement, right? That's the concept, right? Because that increases the unreasonability of the restraint. That's the concept under contract act, right? So we always tell clients that you try to limit to what you really want rather than going and seeking for the moon, right? It will improve your chance of enforcement. Then the client comes and says, but my business is digital, which means that I don't have any geography fixed by way of cities or states or countries, right? It's online. Can I divide my geography as online versus offline, right? can I say that it's online? So, it's online business and offline I have no restriction. And would that be a valid geography, right? How do I really create a geography in a online business? It's an online only business, right? That becomes a question. And while I don't think I have seen any case laws on there yet in India, maybe Alipak, you can when you get a chance, if you can touch upon it, that great. But the way I look at it, if this kind of cases will come to the court, my view is that courts are going to take cognizant of situation, the development of the business, the way things are going. They will take care of that and kind of agree to say that geography where the business makes it irrelevant, right? Then we will look at as online versus offline, as opposed to looking at cities, countries, and the world, right? So instead of looking at that perspective, they will look at it from perspective of online geographies, right? And again, the restrictions maybe with respect to even in online there can be further restraints or further restrictions. It can be, if the business is just focusing on a particular market, right? Just give an example. There's a business which focus on urban market, right, and not on rural markets. Maybe courts can look at it and say, okay, we will give you urban market online rather than rural market online, right? So we think there's always been a way where you can delineate the geography. And I think, in my view, courts are going to look now geography not just in terms of cities and countries, but also the market in which they are, addressing. And this could be online, or it could be, a segment of an online market. With this, let me go back, Soumya. Again, important aspect on negotiation. You very interestingly talked about how what promoters will start thinking in terms of I want to make passive investment here, and you talked about I'm if I go less than 10%, then I become a pure investor, and then you should not put all this restriction on me, right? So what are the negotiation points which you see, both from both sides perspective? Can you just go a little deeper in the negotiations, arguments for and against this?
Sure. So, from the perspective of the seller, of course, the most common sort of arguments that we see is, the statutory argument basically is that this is my core skill set and lack of um, livelihood options, etc. Also, some of the arguments that we also see are contractual, but most of these arguments are to restrict the scope of the non-compete and not to completely eliminate the non-compete restriction. So some of the things that promoters and their counsel say while arguing or negotiating non-compete clauses, first of all, the existence of other restrictive covenants. So, for example, in most of the since Weber brought up an online world, and how the geography and the borders are merging in that sense. Similarly, even for employees, for example, there could be arguments that I'm anyway bound by a non-solicit, which restricts me from taking away customers or from soliciting employees, etc. That restriction is there. Similarly, in terms of IP, it is completely protected. So, as part of the due diligence exercise, when you're preparing for an acquisition, especially for tech companies, IP is something that is closely looked at. So anything that has been developed by the promoter completely gets assigned to the company. So hence, from an IP perspective, ownership perspective, the buyer is covered. Also, there are appropriate obligations on the parties in terms of confidentiality, trade secrets, etc. Also, one interesting thing is, I think from an Indian context, even though these clauses are common, I think the general understanding, even amongst lawyers, is that these kind of clauses work more as a deterrent because there is a big question mark and a sort of gray line over enforceability of these clauses. So that is also a point that comes forward in negotiations, and hence parties try to keep these clauses restrictive also to the extent that it can be enforced. However, from a buyer's perspective, one of the key arguments is that, the legitimate protection of the acquisition. So the buyer usually says that, I'm investing so much into this business. So for me, it is important that at least till the time the acquiring entity gets into the business and creates a goodwill for that entity and a separate brand name, etc., the promoter should be prohibited at least to a certain extent so that the goodwill that the buyer has paid for doesn't get diluted. And also, accordingly, buyers also try and negotiate for a wider clause, but that is not always recommended. Again, going back to the enforceability, like Weber spoke about, the wider the restrictions are, you're just limiting your chances of enforcing them. So these are some of the interesting sort of tastes we get to hear while typically negotiating these clauses.
Thank you. No, I think Saumya, you made a point, right? We always there is a doubt on whether you can enforce it or not, right? But you always want to create a deterrent. Deterrent from a lot of perspective, right? It is also a moral obligation, right? It may not be legally enforceable sometimes, but also from buyer's perspective, it puts a moral obligation on the seller, right? If seller is ethical and at least he knows what the buyer expects, right? And there are reputations involved, there are future, he will get into the future business and he will get future investors, he'll get future buyers. If he behaves in an unethical manner, that will affect his reputation, it will affect his ability to do business in future, right? So, so there are greater consideration just than trying to enforce. And this is something from drafting perspective people keep in mind. And especially when you are a lawyer, you need to tell a client. When you advise a client, you need to be very cognizant of telling him why you are keeping that clause and what can be enforced and what can't be enforced. But then the question really is that, look, if there are no enforcement, the way if I draft there is no enforcement, right? Then client is simply, or buyer is simply relying on moral obligation with the seller will have, right, or promoter will have, right? So in order for us to draft a right clause, we need to understand what can be enforced, what can't be enforced. And this is where, Alipak, I come to you. Can you tell historically how courts have looked at this non-compete clause?
Sure. I think there have been plethora of judgments. For the purposes of today's discussion, I'll only focus on 3 or 4 cases. I mean, we have prepared a summary of about 40 cases in one of our research papers called Employment Contracts in India, Enforceability of Restrictive Covenants. It's there on our knowledge site. If one peruses that, you can get a sense of those 40 or 45 cases which have been decided in the last 50 years. Now, having said that, the starting point of this analysis is the 1962 case of Supreme Court in Niranjan Shankar Golikari versus Century SPV. I think this was the starting point when Supreme Court was, for the first time, in my view, asked to opine on Section 27 of the Contract Act and what is the jurisprudence out of it. And for the benefit of everyone, I'll quote the relevant passage for everyone's understanding. So in this case, the Supreme Court enumerated the test for determining validity of restrictive agreements and held that considerations against restrictive covenants are different in cases where restriction is to apply during the period after termination of the contract than those in cases which is to operate during the period of contract. And this aspect, which we have discussed at length before, negative covenants operative during the period of contract of employment when the employee is bound to service employer exclusively are generally not regarded as a restraint of trade and therefore do not fall under Section 27 of the Contract Act. However, a negative covenant that the employee would not engage himself in a trade or business or would not get himself employed by any other master for whom he would perform similar or substantially similar duties is not therefore a restraint of trade unless the contract as aforesaid is unconscionable or excessively harsh or unreasonable or one-sided. Now, this is the first case where Supreme Court provided the guidance. Supreme Court basically carved out an exception saying that, well, even post-termination contracts could be enforceable subject to them not being unconscionable, excessively harsh, unreasonableness, or one-sided. Now, this was in 1960. Over the years, obviously, new principles have come and courts have looked at it slightly differently. The next case which I wanted to discuss was Parikh v. Mark versus Zahir Khan. This was a very famous case decided in 2006. Although the facts of this case are did not relate to a non-compete provision, but nevertheless, Supreme Court held that while considering provisions of Section 27 of the Contract Act, neither the test of reasonableness or the principle of restraint being partial is applicable unless it comes under the exception of goodwill. So the first threshold is one needs to come under the definition of goodwill, and thereafter all the other exceptions, whether the contract is excessively harsh or whether there is reasonableness, these aspects will follow subsequently. In this case, the Supreme Court also held that under Section 27 of the Contract Act, a restrictive covenant extending beyond the term of the contract is void. This is sort of a reiteration. This has been held. This is the law on this point. This has been held in several cases. The doctrine of restraint of trade does not apply during the continuance of contracts for employment, and it is applied only when the contract comes to an end. Now, the next case which I will deal, this is a very important aspect. This is the Wipro case, where Delhi High Court looked at whether the considerations will equally apply vis-a-vis an employee as well as a commercial party, or whether there is a need to create a differentiation on the threshold or the test of Section 27 to be applied in those circumstances. Now, let's understand the facts of this case to better appreciate the case. In this case, Wipro, it worked as a sole and exclusive representative for a company for 17 years. Now, this was a foreign company which was thereafter interested in doing direct operations in India. They sought advertisement and they sought recruitment from people. People could apply. Wipro challenged that, saying that this is in violation of non-solicitation clause in the contract. Now, Delhi High Court was called upon to decide whether indeed this was a violation or not. Now, in this case, Delhi High Court held that negative covenants between the employer and the employee contract pertaining to the period post-termination and restricting the employee's right to seek employment and to do business in the same field would be in restraint. So that's one aspect to it. However, and more importantly, Delhi High Court said that while considering a restrictive or a negative covenant and for determining whether such covenant is in restraint of trade, business, or profession, the courts take a stricter view in employer-employee contracts than in other contracts such as partnership contracts, collaboration contracts, franchisee contracts, agency distribution, or commercial contracts. So the rationale adopted by the Delhi High Court was that in commercial contracts, the parties are expected to have dealt with each other on more or less equal footing. That is, there has been an equal bargain power. Whereas in employer-employee contracts, there is no bargain as such, and you just sign a document. So on this basis, Delhi High Court carved out that exception and balancing both the interests. Now, with that, I'll stop here. Maybe I'll get on to another one or two cases which I have. Now, before I do that, I saw one or two very important questions, and maybe this will help in answering one or two of them. One question over here is that would a dispute as to the sufficiency of consideration have an impact on investors' ability to enforce a negative covenant? And this can be merged with the other question on promoter. If he sells his entire shareholding, is it fair to ask him to put a non-compete provision? And most of these investment agreements, at least in my experience, in dealing with a couple of big arbitrations on this point, there will also be a control premium agreement in such circumstances, which will sort of provide a consideration expressly on the point that you are not being allowed to continue with your existing business for there could be a lock-in for 5 years, 7 years, or 3 years. Against that, a premium is paid. That becomes very important for an arbitral tribunal or a court to look at. Well, there is a restriction, but against that restriction, a substantial amount of money was paid so as to look at both the sides.
Thank you, Alipak. You know, I think you very nicely summarize all the case studies, right? So that's great. But are there any other mechanism through which the restriction can be enforced? What have you seen in the market?
So, not necessarily non-compete, but so the broader bucket is uh, negative covenants. And again, under that, we can have non-compete, there could be non-solicitation, there could be non-disclosure obligations. So yes, for non-solicitation of employees and customers, broadly, the courts have enforced it, even for non-disclosure obligation arising out of confidential agreements, trade secrets. Courts have broadly sort of uphold these obligations. But I'm going to cite two case laws. I mean, they have sort of set out the law on this point. The first one is a Madras High Court case. In this case, the court held that the non-solicitation clause would not apply, but still it goes on to set out the law, and which is why I thought this will be relevant for our discussion. So the Madras High Court held that merely approaching a customer of a previous employer does not amount to solicitation until orders have been placed by such customer based on such approach. So the court looked at the real and effective, not just a stipulation, but what was the impact of that clause? What was the impact of the allegation which has been sought to be litigated? Now, in this case, the High Court held that solicitation is essentially a question of fact. The appellant should prove that the respondents approached the erstwhile customers, and only on account of such solicitation, customers placed orders with the respondent. Here goes the court realized the court looked at the impact of the allegation over here. Mere production of quotation would not serve the purpose. It is not that the appellant is left without any remedy. In case the court ultimately holds that the appellant has got a case on merit, they can be compensated by awarding damages. The supplies made by the respondent to the erstwhile customers of the appellant would be borne out of record. There would be no difficulty to the appellant to prove that in spite of entering into a non-disclosure agreement, respondent had solicited customers, and pursuant to such solicitation, they have actually supplied castings. So the real and effective impact is what one needs to look at. Now, with respect to confidentiality, and this is again a very celebrated case, there was a law firm, and I don't want to name it. There was a law firm, and a couple of employees from this law firm, they sort of took out confidential information, such as the erstwhile drafts, the client confidential information, so on and so forth. And basis those information, they tried reaching out to clients to do a new business. Now, Delhi High Court came heavily on these advocates who tried to set up their own business. Delhi High Court held that you cannot use information which you have accumulated in your past employment. However, the Delhi High Court did not restrain these people from continuing the legal profession. Yes, these are the two in my view, these are the two different angles. I mean, not exactly non-compete, but although they come under negative covenant, which can easily be enforced if it is worded very strictly under the contract.
Thank you, Alipak. Now, here it reminds me of a lot of questions which I've encountered during my my experience over last many years, right? Often the question comes is saying that, look, if I'm buying 100% of the company, right? But I'm not buying the business, right? If it's an asset sale, slump sale, yes, it's very clear that it's a sale of business, and because I'm buying the whole business, it's also going with goodwill. If I'm not buying, I'm buying a part business, then the question comes: is there a goodwill or not? And that becomes a questionable thing, and we're not covering that, but that is also a very interesting aspects of. But that is not a fact specific. That if you're buying a part business in a slump sale, then is there non-compete, and it's a very fact specific thing. which is whether the goodwill actually is going or not, right? In some cases, some goodwill is being shared. Then that's different. But a lot of time, the goodwill is not shared, and somebody just buys the business, but not the goodwill, and then there cannot be a non-compete for that particular thing, right? But most of the transactions are actually purchase of shares and not really a business. Then the question comes is that purchasing of shares, is it equivalent to purchase of business or not, right? And whether I can say, buying 100% of share is equal to buy 100% of the business with goodwill, right? I think, in those kind of scenarios, the answer is yes. Most, if you're buying 100% of the company, you're buying business with goodwill, because that's the end result. And when the courts are going to look at it, they're actually going to look at it the actual effect, right? So that's in my mind a simple question to answer, even though this is an important question and I have not seen it really litigated. But complexity starts coming when you are when you are multiple owners of that company, multiple shareholders of the company. And I think earlier we discussed there are three kinds of shareholders, right? One, there are promoters, other they are employees, and third there are passive investors, right? And we talked about passive investor or financial investors, and they don't even want this particular restriction to be there from negotiation perspective. I think even if it is there from um, from negotiation perspective, those kind of clauses have been kept in. I really doubt we can say that they have actually sold business with goodwill when they are owning, let's say, 10%, 20%, 30%, right? Then comes situation of a promoter, right? Because that, in my mind, financial investor, in my mind, is little bit easier to interpret. Again, it will depend on facts and circumstances. So I will not put a carte blanche statement, but chances are that they will not really be subject to the enforcement of non-compete if they were simply a financial investor holding a small percentage. But when it comes to promoter, right? Promoters, if they're holding, let's say, not holding 100%, but they're holding 51%, right? In which case, there is a good chance that non-compete may be enforceable, because fundamentally, if they are controlling the company and they are selling the business, a call can be taken, right? That the result is that you are actually selling a business with the goodwill, right? Because 100% of goodwill is 100% of the company is being bought, and others are financial investors. So it's a reasonable restriction to put on the promoter, on whose goodwill, whose effort the goodwill was created. Then the question next comes is, what if the promoter is not one promoter, but there are a bunch of individuals, right? There are 3 or 4 promoters, and those promoters are holding, some of those are holding, let's say, lesser than, so none of them are holding 51%. Obviously, some are holding 10%, 20%, 30%, and all put together they are holding 50%, right? Then what is the situation, right? In which case, can we combine all the promoters and say, hey, this is a bunch of promoter, and we should say, they are, it's a collective thing, rather than looking at each promoter individually and then say, well, I don't own, one promoter says that I don't own more than 5%, I can't be held liable for this covenant, right? uh, how is court likely to look at it, right? The court, in my mind, is likely to look them at as collective rather than individual, because that's a collective way how the goodwill was created, right? That's the way I look at it. I have not seen the court's many judgments on this level, on this point, but in my mind, courts are likely to look at it more collectively basis, and if collectively somebody is holding 51% or control, then there are more chances than not, then court will go and say, this group of people, there should be enforcement. Then you look at, then questions I get is situations where promoters are actually owning just 5% and 10%, right? And not more. And then substantially there are financial investors who hold majority, and that is some of the recent trends right now. And then the question comes is that if a promoters put together own, let's say, 10% or 15%, really, can we put this restriction on them, and can we enforce the restriction on them? Because specifically, the sale of business, they only own 15%, right? And this is where it will depend on facts and circumstances. It may be possible, it may not be possible, uh, but it's going to be difficult to enforce. As an when the promoter's shareholding starts reducing, it is going to be difficult to enforce. That's the view which I think the courts are going to look at it. And then the question really comes for senior employees, right? Who holds ESOP? Most senior employees will have ESOP, and most of them will have a situation where they will have they would have sold the shares to the buyer, right? And we always say that enforcement for non-compete is slightly separate, but if somebody is seller, then it's a very different. And those are the people who own maybe 1%, half a percent, 0.1% of the company, but they have been critical people for developing the business. And the question comes is, can I know I can't use them. They're, I will have a non-compete in their employment agreement, and I know I may not be able to use it beyond their termination of the employment agreement. But can I really use this clauses for perspective of considering them as a seller, right? And considering that they are selling business with goodwill. My view is that, look, it's going to be very tough going on that part. But keeping in mind that, look, this doesn't really go to the court. This all agreements are under arbitration, and arbitrator have a lot more leeway in looking at how the what was the intention of the party and how the law is to be interpreted. In, of course, they will do in line of the law, but the point is that there is a lot more informality which arbitrator has. And most of these arbitrations are confidential, so you don't know if there have been arbitration, what kind of judgments have come in. And also difficult to challenge arbitrators difficult to challenge arbitrators uh, judgment in a very limited grounds on which you can challenge it. So the way I look at it is that in arbitration, little bit better chance of getting this enforced than in courts. But these are all questions which I don't think we have answers to, and especially in some of those situations, it may be difficult and it may be tricky. In some situations, it may be a little easier. But these are the new things which I don't think the law, when it was drafted, actually anticipated. So with this, and again, I've only taken a situation where it's 100% share of companies which are being sold. What if buyer is buying just 51%, right? Can be non-compete be enforced against the 51% seller, right? So those kind of questions also will come in. To a large extent, they will be in line, which is similar to what we discussed in earlier discussion. But always these are interesting points which we will not be able to address. I know there are a lot of points we wanted to cover more, but I'm cognizant of time, and I will go to Alipak and ask him to talk about garden leave. There's one question which has come in. I'll go to the Q&A. There's a question which comes in and which talks about the enforceability of garden leave. Alipak, can you spend some time just talk about enforcement of garden leave?
Sure. I think the only so garden leave has, for the benefit of everyone, I think it's a mechanism built in a contract where the employee who has been asked to leave or who leaves the company, in case of a senior person, they are paid their regular salaries, and they have been asked not to take employment somewhere else. It could be 3 months, could be 6 months, could be 12 months. Now, the only piece of guidance that we have here is the case of Bombay High Court in VSS Global Services versus Mr. Suprit Roy. This is a 2008 case. In fact, very interestingly, Bombay High Court held that garden leave arrangement again falls foul of the law, insofar as this is a contract which extends beyond the regular contract of employment. Consideration may be paid, that's fine, but to the extent it relates to a term which goes beyond the regular employment contract, it was held to be non-enforceable. Having said that, this is a 2008 case. In the market and in the industry, there are a lot of cases where garden leaves are successfully being used. We don't know when it will be tested, and like Vaibhav, you correctly said that most of these disputes are fought in an arbitration where the proceedings are confidential. even if, and when the award is passed, there are very narrow grounds on which you can challenge an award if it is an India-seated award, or you can resist an enforcement if it is a foreign-seated award, very limited grounds. So we don't know. But as on date, the only case law where we have, it's a 2008 case where Bombay High Court refused to sort of enforce the garden leave clause.
Thank you, Alipak. So we have already addressed question from Ishan, we have addressed question from Anita, from Samir. Let me go to, I think Gaurav also we have addressed, right?
Yeah.
Let me go to Ishan's one question. His question is, even if shareholding is less, affirmative rights might give them control and hence making a non-compete enforceable. I don't know. It's a question or a statement. I didn't see a question there, but I think we already discussed this to some extent, right? Control may not necessarily be relevant from non-compete perspective, whether you had a control or not. Even if you didn't have control, you can still be part of non-compete clauses. So I don't think, in my mind, control is it may be one of the factors to determine, whether you developed goodwill and you sold goodwill, but not, in my mind, the only factor, or that factor. Now, there's a question from Sakib, right? If the court does not find non-compete to be reasonable, is it possible for it to redefine the limits instead of completely refusing to enforce it? Soumya, I know this was a question which you have dealt with. Can you talk, especially in maybe Alipak you can add, but how in India and elsewhere looks at it?
Sure, I can probably just quickly discuss, how actually we very commonly face, this particular point on cross-border deals, because different jurisdictions non-compete restrictions differently, and I'll, let Alipak speak about it from the perspective of Indian courts. But generally, what we've seen is across some states in the US, for example. So what Saqib is mentioning is something that we call a blue pencil approach. Basically, it is really the concept of severability. The courts will look at the clause, and the courts are allowed to modify the clause to the extent that it becomes enforceable. So there are two possibilities, right? One is if the court finds the clause to be unenforceable, the simplest approach would have been to strike down the clause, saying this is not applicable. The other option is what we call the blue pencil approach, where the courts are allowed to sort of restrict the scope and extent of the clause. What we've seen is really in the states where this blue pencil approach is allowed, we've seen a lot of resentment even amongst the negotiating parties to still follow that approach, because what really happens then is that because of the power of the courts to do this, the parties generally leave the clause so wide that it eventually gets to court and it becomes a subject matter of litigation. So even though this approach is followed by certain courts, we've still broadly seen parties, that they prefer to just limit the non-compete clause in the contract itself. Maybe Alipak can just also add a line or two on how Indian courts look at it.
So I had I'll give an example of one of the cases which I have done. So in a SIAC arbitration, it had a non-compete clause, and the tenure of the non-compete was linked to, this was an earn-out arrangement in the transaction document, where the Indian promoter was selling off their business to a foreign counterpart in tranches over the period of 5 years. And the value was linked to how the company performed. The value in the sense, the promoter's return was linked to how the company performed in the 5 years. So there was a non-compete imposed, and the tenure was linked to the last date on which the sale of shares take place. That date plus 2 years. Now, because of certain regulatory restrictions, the final sale of shares could not take place for about 6 years. Now, in that scenario, obviously our clients, scenario where the non-compete was operating for 6 or 7 years, and they had no remedy and there was a dispute, and the foreign counterparty was constantly threatening that I will sue you because if you continue to do a business similarly like this. So we went before the cCep tribunal. The courts took a view that this amounts to a non-compete in perpetuity, and it struck down the contract. And keeping the view of reasonableness, the court looked at the fact that at the time when this contract was drafted, it stipulated a reasonable time, could be 3 years or 4 years, within which you were supposed to finalize the transaction. It could not happen because of certain regulatory restriction, but that does not mean that the non-compete works for perpetuity. So even in other instances, we have seen that the tribunals, mostly tribunals, not so much courts, they take a very reasonable and a commercial approach to deal with such kind of clauses.
Thank you, Alipak. Thank you, Saumya. I think we are running out of time. We are already over time by 2 minutes, but I will just address these 2 questions before we end. And I know there have been a lot of interesting questions. Sorry, we can't take every questions which have come up. But just two questions here. One is, do we need to assign a separate value to goodwill in case of 100% acquisition where acquirer wants to have a non-compete clause against the promoter? This is from Kunal. The answer is no, you don't need to assign a separate value. As long as there is a clarity that goodwill is being transferred, that's good enough, right? So anything else is not required. Then question is another by Vaidya. It says, if employee contacts customers of an erstwhile employer for business purposes, is it an offense as per law? Now, this is a very interesting and important question. It may not necessarily relate to non-compete in an M&A transaction. It may sometimes, but it's a general question, and this requires a lot more detailed discussion with time which we don't have. But just 2-3 points here. First, this is not a non-compete, right? This is a non-solicit, and non-solicit enforcement, non-solicit clause is enforceable. Non-compete is you doing that business, right? And for that business, you don't necessarily have to go and contact the erstwhile employer's customers, right? You don't need to. So this is more like soliciting the business away from your erstwhile employer. So question is, this is not non-compete, this is non-solicit. Again, in this non-solicit, there are a lot of questions, and how you acquire. Are you soliciting, or you were just advertising and customer came to you, right? Because while you may have restrictions on non-soliciting a customer, if a customer comes to you, right, they don't have any restriction in doing business with you, and as a result, you may be able to do business, but if you have a non-solicit clause, and if you are going to go after the customers of erstwhile employer, then there could be a possible breach. So we are not going into details here for lack of time and lack of discussion, but that is it. But there's also one other point I want to just tell, which we have not addressed in detail here, which is also a situation when employee leaves the company and joins a competitor, and he actually carries intellectual property with him. And a lot of time the company is not worried about the person joining a competitor, but is worried about dilution of his intellectual property being leaked to the competitor. And this is a situation where courts are looking at it a lot more seriously now, and that's the recent trends, even worldwide, including in India. And often, while you can't stop him from joining it, you can definitely stop him from disclosing the intellectual property. And in a situation where his business or his role is such that intellectual property will be disclosed, then there is a good chance where the person who is going and the erstwhile employer can go and actually say that, look, while I don't want to restrict him or non-compete, but give me an order with respect to non-disclosure of intellectual property. And because of this particular order, if he ends up working there and he ends up disclosing, he will end up violating the order. So that's the way people can deal with it. With this, I will close the session. I have Nishith Desai, who is with us also on the call, and I apologize. I'm 5 minutes over that, but I want to give this opportunity to Nishith Bhai if he wants to say any word before I hand over to TN.
Well, I think it was brilliant discussion and elaboration, and I'm happy you could address so many people's question. I hope that has been very useful. I think this is a very educative session, and hope everybody is finding some value in it. We must thank all the participants for joining in so many numbers. It seems that there's a lot of interest in these kind of subjects, and we are trying to see that whatever little we can share, whatever we can provide the information. I think it gives us a lot of excitement and satisfaction as well. So thank you all for joining, and thank you Vaibhav, thank you Alipak, thank you Saumya, thank everybody around, and really appreciate your coming on board and spending your valuable time. Thank you.